Welcome to the Canadian Intellectual Property Office, CIPO's, educational video series called IP Protection Abroad, Leveraging IP in New Markets. Part 2. Minimize Disclosure. In the next few minutes, we'll talk about the things you can do to minimize the disclosure of your intellectual property, or IP, and other business-critical information you should consider keeping secret. Talking about your IP before you protect it will increase the risk of imitation and counterfeiting and may prevent you from obtaining formal IP rights. To minimize the risk of this happening to you, protect sensitive information as trade secret before and while you seek formal IP protection. Only disclose this information on a need-to-know basis, both internally and externally.
Let's go over 3 basic steps you can take to minimize the risks of disclosure. Step 1. Start by identifying the sensitive information and, if possible, divide it into parts to keep sharing at a minimum. Step 2. Protect your secrets internally. Educate your employees, restrict access to sensitive information, and keep that information locked and encrypted. Step 3. Sometimes you'll need to share parts of information outside your company, so make sure to have agreements and protection in place before you do so. Be the master of your secrets. Assess and define the minimum information you're required to share with your employees and partners and with outsiders. Be very selective when you reveal information. Only disclose it on a need-to-know basis. Many experienced business people won't sign confidentiality contracts, so you'll need to know how to talk about your invention with stakeholders, such as potential investors, manufacturers, and distributors. Therefore, you'll need to have a structured plan and some practice for how to talk about your invention without disclosing critical information. Think about where discussions will take place. In what country and context will it be, and who else will be present? And also think about what you're discussing. For example, you should only discuss what your invention does, not how you created it. Then, consider who you're talking to and what their interest is. If you're talking to a parts manufacturer, for instance, only disclose the information they need to do their job. Finally, consider when the discussion is taking place. In the early days of building, testing, and verifying your creation or invention, make sure you don't disclose information that could allow someone else to copy your creation or invention. This includes talking about, showing, or documenting the information.
Keep sensitive information where it belongs. You may lose it. So, don't bring prototypes, drawings, notebooks, or similar things to venues where exposure of this information would be a critical risk to your business.
Likewise, limit site visits to your research and development facilities. If site visits are required, take care to protect and remove from view any sensitive information.
Step 2. Protect your trade secrets internally. Employees are the ones most likely to disclose a company's valuable trade secrets. This can happen either inadvertently or purposely. Minimize and limit access to confidential information to only the employees who need access to carry out their duties. Appoint an expert in confidential information to review and pre-authorize correspondence with third parties.
It's important to educate your employees on protecting your trade secrets. Let your employees know what information is considered confidential and can only be disclosed under non-disclosure agreements. Teach them about these agreements and how to use them. Limit the accidental sharing of trade secrets by educating and reminding your employees about the importance of trade secrets and how they're kept. Create a written policy describing how confidential information is to be managed. Record the existence of trade secrets and track the names of people who have access to them. Restrict the distribution of the information through confidentiality agreements. Keep the information locked and/or encrypted electronically.
Also, make sure you can track access to the confidential information. A document tracking system can be valuable if you investigate trade secret thefts. It can prove that the company took measures to protect the trade secrets. Limit access to only those with appropriate access privileges by using encryption. Record the user identity, the duration, and time of access to confidential documents. You may also want a date and time-stamped digital fingerprint of a file so you can prove you were in possession of the original file before anyone else.
Although some jurisdictions have trade secret protection, The owner of a trade secret usually needs to prove that the secret has economic value and that steps were taken to avoid disclosing the critical information.
Step 3. Protect your trade secrets externally. Restrict access to trade secrets to only the employees who need it. It's best if only one person is the lead on confidential information. This person can then provide assistance to other employees and verify that outgoing content in meetings and emails is free from confidential information.
Yes, and also consider the timing of keeping things secret. Assess the timing of sharing information. For example, don't disclose your patent application or industrial design registration ahead of filing. Until you have formal IP protection, establish confidentiality or non-disclosure agreements with your employees and partners and with outsiders. Whenever possible, use supply agreements or demonstrate outputs rather than disclosing the trade secrets themselves.
These were the most critical steps you need to take to minimize the disclosure of business-critical information. You may need to rely on these methods while you seek formal IP protection, or indefinitely if you want to keep the information as a trade secret. IP laws and regulations for formal IP and trade secrets vary between jurisdictions. Be sure to watch the next video in our series on IP protection abroad to see how you can find existing IP and learn about related regulations and procedures before you apply for protection.